We've heard Kellen Winslow II talk about the sexual misconduct case against him.
I'm an innocent guy. I'm an innocent man.
Several times.
It's a money grab. It's a money grab. And
the one place the former NFL star won't address the case from, the witness stand.
Yeah, I'm not going to testify.
Oh, all right.
But others did testify, including the daughter of Jane Doe #1 for a second time.
And then you took the post down, right?
I did, because I was receiving threats online.
And after calling just 5 witnesses, the defense rested its case. Now, on the eve of closing arguments, did Winslow's defense team do enough to raise a reasonable doubt? All right, this is the eve of closing arguments, but I want to take a moment to go back to the opening statement from the defense. Brian Watkins, so passionate inside that courtroom, so effective, laying the foundation for the defense case. He had an explanation for the rapes, Jane Doe 1, 2, and 3. It was sex. No strings attached sex. He would not even dignify it by calling it an affair. No, it was just sex. It was consensual. Okay, I was like, wow, this is going to be some trial, because we're going to have these Jane Does come into the courtroom, tell their stories, and then it's going to be the time for the defense to tell their story. And that story has to be told by one person and one person only. Kellen Winslow II, right? If it's consent, he was there. If it was consent, he can say exactly what happened. A classic she said, he said case. Only in this case, he never said anything because he did not take the witness stand. Kellen Winslow II does not testify. It's my biggest moment of the day.
Do you plan on having your client testifying?
No.
Okay. All right, Mr. Winslow, I need to tell you that the decision on whether to testify or not is your decision. Oh, you can remain seated. It's okay. Yeah. The decision to testify is your decision and your decision alone. Of course, you have excellent attorneys who have conducted the trial, and I would expect that you would discuss that with them. But the decision is ultimately yours. You have an absolute right to testify on your own behalf, and you also have an absolute constitutional right not to testify. If you do not testify, I will instruct the jury as follows. A defendant has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people have failed to prove the charges beyond a reasonable doubt. Do not consider for any reason at all the fact the defendant did not testify. Do not discuss that fact during your deliberations or let it influence your decision in any way. That's what I will tell the jury if you decide not to testify. So the decision is yours and yours alone. Have you had enough time to discuss this decision with your attorneys?
Yes, Your Honor.
And is it your decision alone not to testify?
Yeah, I'm not going to testify, Your
Oh,
Honor.
all right. Then I will instruct the jury according to the law, which I just read to you. All right.
Yes, Your Honor.
And this is the foundation of our system of justice. Everyone is presumed innocent. You do not have to testify. You can't be compelled to testify. And the fact that you don't testify can never, should never, ever be used against a criminal defendant. If it is, our system absolutely crumbles. That being said, let's go back again to that opening statement. Consent is the defense. So I've got to bring in our Court TV legal correspondent, Chanley Painter, outside the courthouse. Chanley, okay, he didn't testify about consent. Did anyone take the witness stand throughout the course of this trial and say that those alleged attacks, those alleged rapes, were consensual sexual behavior?
I didn't hear it, Vinny, and you notice on cross-examination a couple of times Mark Carlos insinuated it might have been consensual. For example, Jane Doe #2, he asked, had you talked about sex with each other before? Or he offered to pay you for sex, those little things. But you got to know that this jury was taking notes during opening statements. They're not going to just forget that that's what was said, and they're going to take that with them through the trial and, of course, into tomorrow.
Now, Jane Doe #4 did testify about having consensual sex with Kellen Winslow before the attack. What was it, 2 weeks before the attack?
It was 2 weeks before the alleged incident that he's charged with, which is when she allegedly was unconscious and woke up to the assault between Matt Vaughn and Kellen Winslow. She said stop, Kellen Winslow wouldn't stop. So that, yes, 2 weeks before, and she testified on the stand. That's why she didn't come forward originally, because she had consensual sex just 2 weeks prior. Who would believe her?
Now, inside the courtroom, all this is done outside the presence of the jury. Just want to make that clear for folks at home if they don't know. So they don't see that moment. We did see it, and we saw Kellen Winslow today, and he seemed a little different. His demeanor seemed a little bit, I don't know quite how to explain it. How would you describe the way he was today compared to the rest of the trial?
He seemed a little more nervous today. He was a little anxious. We see that in the video where he just kind of stands up automatically, and the judge is like, no, sit down, relax. We'll walk through this. That was, the jury wasn't present, like you said. But my sources are telling me that he's still really confident. He feels good about what's going to happen. He has faith that justice will be served for his side.
All right, let me bring back in my think tank, and let me start with you, Ray. Doesn't have to testify. Most criminal defendants don't testify. Most times attorneys like you tell them don't testify, I think, right? I don't know what you do personally, but defense attorneys generally. It's a consent case, though.
Yeah, sort of like self-defense. For me to argue self-defense, I've got to say, Politan was coming at me with a Louisville slugger. I backed to the wall, and then I told him to stop, and then I shot him, okay? That's hard. The best way to prove that is for me to show my state of mind. Consent is a state of mind. I consented to have sex with Mr. Winslow. Sure, we had some drinks. Maybe it was a little rough or not exactly what I expected, but I gave him permission. That's what he needs to testify to. Now, the defense has sort of weaved this, and I know where this is going, at least I think. Earlier in the show, we saw a former teammate of Kevin's at the Browns. He had a black baseball cap on. And when the reporter asked him about these sexual assaults, he kind of shrugged it off, said, he don't need that. That's right. That's the defense. He's bright, he's handsome, he's wealthy, he's charming. He married his high school sweetheart, and they have 2 beautiful children. He doesn't need to force anybody to have sex with him. And that's where this trial is going, and that's where the defense may have overpromised a little bit in opening, and that's law school 101. You have to be careful, but I think that's how they're going to weave the closing. It's consensual because he is who he is.
He is who he is.
He is who he is.
I think it would have played out a lot better if they were able to get him into a position where he could testify. I think the fact that he's not testifying is going to, even though the jury is going to be instructed that they are not supposed to consider it, the likelihood of, they have to wonder what he's been thinking. He's taking notes, he's talking to his lawyers throughout the trial. They have to wonder, what does he have to say for himself? And if he doesn't get up there and say some of these circumstances were consensual, then they don't really have evidence of that. I agree. I think they're going to end up arguing that why would he go out of his way? But why is he picking up homeless women 20 years older than him? I mean, that's the other problem.
That's another unexplained thing. Lieutenant Colonel, he did tell investigators that it was consensual. That evidence never came in front of the jury because it's hearsay, it's a self-serving statement, out of court, right? Never came in. How do you, as an investigator, determine whether or not he's telling you the truth?
You can't without evidence. If it had not been for the DNA, well, take it back. If he had said he never had sex with Jane Doe number 1, this case would be over, right? The DNA, proof positive,
Exactly.
You were there. So he was compelled to admit, at least say that, hey, it was consensual sex. Because if he hadn't, game over with. And I'm sure his attorney told him that. You better just go ahead and admit you had sex with this woman because they have your DNA. And if we say you weren't there, your DNA says otherwise. You were there.
And that statement that I wasn't there comes in. Vic, let me ask you a question I ask a lot of criminal defense attorneys. Factual innocence versus, he's not factually innocent. Does that come into play in determining whether or not a criminal defendant should testify? Whether they actually did not do what they're accused of, and in this case, it's forcible rape. Does that weave into the equation on whether or not they should testify?
Oh, absolutely. And when you have facts that support a defense argument or a theory of the defense, well, then you can rely on the presentation of those facts and then dovetail all of that into an argument during closings with the jury instructions and say, well, we didn't have to testify. It's our given right not to, and you all know that, and you have instructions saying you have to do that. But that's all law. And even as a lawyer, as a trial lawyer, I will tell you, when you talk about the right not to testify, it goes in one ear and literally out the other. And I'm a defense attorney that should really have that imprint upon my mind. Now, this is what jurors do. Jurors understand that defendants have a right not to testify, but they don't like it. And the reality is, when you're talking about a case in that compartment that I would say includes domestic violence offenses and sexual assaults of every type and nature, if consent is an issue, you must, in my opinion. Now, let me also say that the attorneys here are doing a good job given the facts that they have, but you must call the suspect to testify. Otherwise, there's absolutely no hook to hang your defense hat on.
If I can interject, I would suspect that these are really good lawyers.
Absolutely.
And they've had their client out on bond. And let me tell you, when you've got your client on bond and he or she can come to your office anytime you want, and you can put him in a conference room instead of talking to him through the plexiglass window on the phone down there in the Gray Bar Hotel.
Right.
You can bring in a former prosecutor like Vinnie Paulton and say, Vinnie, here's the case. Cross-examine him, and we're videotaping him, and we're going to see how he's going to do. We don't know how he did. I guarantee you.
Well, he was out on
these
bond for a
lawyers-
while.
That's right. Doesn't
For a
matter.
while.
But, it's a weekend, man. We make the coffee, baby. We're in there ordering pizzas. We can do this in 72 hours. And I assure you, these veteran lawyers had their client cross-examined by a former prosecutor, somebody. They called him or her up and said, come on and rip him up. And they didn't like how he answered the questions, or they didn't like the answers to the questions, or both. And that's why I didn't take the stand.
Who makes the decision?
Well, I think that obviously the defendant makes the decision, but I do think that it would have been more prudent, and maybe they did have a number of people come in and cross-examine him and make that decision, or I guess guide him to not testify. But I also think that if he didn't testify well and they felt, as a defense attorney in the situation where you're trying to prove consent, that they consented, I feel like you would need to maybe go a step further and see if some of his mannerisms or the way that he comes off could be softened. I mean, those are things that the way
They softened his look for sure. I mean, if you've seen the before and after when he was arrested and how he looks in court today, much, much, much different. All right, folks, want to hear what you have to say. Our 13th juror question. Are you surprised Kellen Winslow II did not testify? Yes.